Hello and welcome. My name is Todd Hutchison and I want to be talking about evidence in this session. See, in an investigation, evidence is critical in creating a case that the allegations can be validated against. Ideally, the evidence provides proof beyond a reasonable doubt, which there is no logical conclusion other than the allegations. There are many uses of the term evidence, some of which are inadmissible in the court of law, although they may help in providing an important piece of the puzzle for generally understanding how and why the alleged event occurred. I want to go through 22 different evidence because it's quite confusing when you hear these terms used to know what they mean. Well, the first one is anecdotal evidence. This is where you seek anecdotes that support a particular conclusion. It is not used in court but can help in testing scenarios. And then you have the hearsay evidence. These are where third-party statements of people not directly involved and is not admissible in court also. Then we have testimonial evidence. This represents an eyewitness account as a spoken or written statement that is generally provided under oath. The fourth is direct evidence. That is evidence that ties the suspect to the alleged event or site without the need for inference. Then you have circumstantial evidence. This is indirect evidence that aims to make an inference based on other separate evidence that effectively is a deductive technique. Then we have character evidence. This is generally a testimony, a reference or document that sets out to ascertain the character, credentials or state of mind of a person. Sometimes this is used to prove intent, motive or opportunity. Then we have habit evidence. See, habit evidence, often referred to as propensity evidence, is linking a behaviour to previous consistent and repetitious behaviour. It aims to suggest behaviour based on previous habitual experiences. We then have expert witness evidence, where a person who is knowledgeable about and a specialist and may have a skill area that present their opinion about the facts or other evidence presented in a court. Then we have forensic evidence. This is scientific-based evidence that uses some form of biometric that represents some humanistic characteristic, like DNA, fingerprints, facial features, and retina scans. Then we have trace evidence. This is the evidence created when two objects make contact with another, like blood splattering. Then we have physical or real evidence. This is evidence in a tangible form that is often referred to as material evidence and may be called an exhibit in a court, and may be documents, audio-visual recordings, or photography and video images. This can be further broken down to individual physical evidence, such as validating their white blood cell DNA, or class physical evidence that represents a particular group of people, a class, such as then looking at the blood group. We then have digital evidence. This is the evidence in electronic format collected from things like computers, photocopiers, cameras, recorders, watches, GPS, gaming consoles, any automated system, controllers, or any other electronic device. Beyond data, it can include capturing dates and times, and it generally is in the form of a document, email, video, or audio recording. And then we have documentary evidence, which is simply referring to written or electronic documents. Statistical evidence is when the numbers and statistics are used as proof. This can include measurements and calculations. And then analogical evidence, well, this is a comparative technique where credibility is increased by drawing parallels to other similar experiences or events. We then have demonstrable evidence. This is when an object or a document is used to directly demonstrate a fact. Now, the prima facie evidence, well, this is evidence based on a first impression or appearance that is accepted as correct until later proved otherwise. Then we have exculpatory evidence. This represents evidence that effectively clears a suspect from guilt or blame. We then have corroborating evidence. Well, this represents evidence that is supporting, authenticating, or confirming existing evidence or the strength of that evidence that builds on for the case. Now, admissible evidence, this simply means evidence that can be used by a court of law. And then you have inadmissible evidence. Well, this is evidence that cannot be used in the court of law. And finally, insufficient evidence. This is evidence that fails to meet the burden of proof. So I hope these 22 terms help you better understand evidence and its different categorizations. Remember, all evidence can provide vital clues and may be used to point towards new areas of inquiry or additional scenario analysis.